Oh, you may be seated. Sorry. Case number A-16-738562-C, Russell Zitch versus Jason Stoffel et al.
Good
Morning, counsel.
Good morning. Shawana Johnson for Russell Zitch.
Morning, Your Honor. Joe Guerin for defendant.
All right. This is a request for exemption from arbitration. Why don't you tell me why this case should be exempted? And I know counsel, opposing counsel, thinks it should not be. So let's start with you, Ms. Johnson.
Okay, thank you, Your Honor. This is a very unusual case. We filed it in June of 2016, and nothing substantive has happened because it's been up to the Supreme Court twice. It's still up there now. I just found out from counsel that it stayed. It's very unusual motion practice because of the claims involved. There's one claim remaining, intentional infliction of emotional distress, and that was allowed to go forward based on what defendants call a novel theory of law, the continuing tort theory, and that had to be briefed 3 times for Judge Bayless. It had to be briefed for the Supreme Court. It's not something that is normally, well, it exists, but it's something that's going to have to be fleshed out by the courts, and the fact that Judge Bayless asked us to brief it a couple of times indicates that if it comes back from the Supreme Court, which we think it will to go forward, that it's going to involve some interesting discovery and also some interesting legal arguments to get past summary judgment. Also, this involves, I confirmed with my client, this involves $27,000 that was paid out 5 years ago. So if we are just calculating the interest on the $27,000, just at the statutory interest, and then if we add in attorney's fees, and if a jury awards my client over a nominal amount for his damages, that puts us over $50,000. I did not submit what I have billed so far for the case, but we've been in it since June 2016, and we've had significant motion practice, so I would not bet that the bill at this point is under $20,000 alone, just from all the motion practice in the Supreme Court and back down and such. So I think that there's a good faith basis to exempt it from arbitration. If it were a run-of-the-mill claim, I'd say, okay, but the fact that defendants vehemently opposed this claim, stating that there was no Nevada law to support it, and then Judge Bayless came back and said that there was Nevada law and we could go forward, I have the feeling that that issue, that legal issue, is going to come up again. So.
Okay, let me just quickly ask you.
Sure.
The NAR 3 states that all cases that are in the district court with a probable jury award of not in excess of $50,000 will go into arbitration, and that's exclusive of interest and costs. So we take the interest out, we take the costs out, and that's just the value of the case, and you're adding in attorney's fees. Under what theory would the damages in this case include attorney's fees? Is there what damages would there be in excess of the $27,000 that was paid out?
His emotional distress. So if a jury could find that there was a continuing tort and that over the 5 years of having to take his attorneys to bar counsel and then through the litigation and through the significant motion practice, the jury could find that as a senior citizen he had to pay his ex-wife this money, he got nothing in return, they could find that he has suffered more than more than $27,000 just on his emotional distress claim, and that's the only claim remaining. So it's, like I said, it's an interesting case. Emotional distress is usually like a throw-in. You just throw it in at the last minute and make sure you get it. However, most of this case is going to be emotional distress because, if you have your attorneys admitting in writing that they made a mistake and then they take you through 5 years of litigation to get compensated for the mistake, then a jury could find that none of that was done in good faith and that, Mr. Zitch has been through the runaround, so they could certainly award him more than $23,000 in damages to get us over 50.
Okay. All right. Thank you. Counsel.
Good morning, Your Honor. First things first, last Thursday, I think, Judge Bayless issued a minute order granting our motion to stay pending appeal. We'd filed a motion under NRS 41660, the anti-SLAPP statute, and that has an automatic right to appeal with mandatory stay. So that's the first reason we really shouldn't do anything today. But beyond that, The case started as a legal malpractice case, and the theory was...
And I just want to interrupt you for just a second. My understanding is that the order has not been filed yet, and that's why we're here today.
I saw the minute order this morning, and I know that the order has not been signed yet.
Okay, I just wanted to address that. Continue, sorry.
So it started as a legal malpractice case where the claim was that my client somehow mishandled a retirement plan with $27,000 in value, and that the plaintiff somehow lost out on that $27,000. Well, that was dismissed for statute of limitations, and it was affirmed by the Nevada Supreme Court, but they sent it back on the issue of the intentional infliction case. So there's really even a question whether the $20,000 or the $27,000, which was an economic loss in the malpractice case, can somehow be transferred over as an emotional distress damage. So that's just even kind of a threshold question, but the more important point is that interest and costs are not included, and then the question about whether attorney fees can be included, there is no theory that's alleged in the case that would allow for fee shifting. There's no statute, there's no contract, and if you look at the case law that actually decides the questions about attorney fees, there has to be something that's done by the lawyer that causes a party to incur attorney fees outside of the litigation. So for example, the typical example is in a title case where the attorney makes a bad title search, and the person who requested the search then has to incur fees to clear up any cloud on title that was missed by the attorney. And that's different than what's going on here. So the claim for attorney fees is basically, well, you defendants didn't include this $27,000 correctly in the divorce judgment, and we're suing you, and now we have to pay lawyers to sue you. And that's not allowed. It's a violation of the American rule, which is basically that lawyers or that parties have to incur their own fees to sue each other unless there's a statute, contract, or court rule that shifts it. And there's nothing alleged here that would even include that. So, is
there a cause of action in this case under Sandy Valley for attorney's fees?
That's the case I was thinking of with Sandy Valley. I don't think Sandy Valley has been alleged specifically in the complaint. But again, Sandy Valley, I think, speaks specifically to what I was trying to say, which is that the attorney fees have to be caused by the attorney's negligence in order for a party to recover those. The attorney fees incurred suing that lawyer, they're not compensable, they're not allowed under Sandy Valley. And so for that reason, we think that the matter should remain in arbitration subject to the stay.
It's questionable whether in the original contract, the original retainer agreement, whether attorney's fees are allowed for the party that has to enforce the agreement. And I understand that we're not here. The legal malpractice has been dismissed. However, I'm looking at the engagement agreement right now, and it does provide for fees and costs as a result of litigation between the parties. Also, if Mr. Zitch, just as the prevailing party, under NRS 18010 could recover attorney's fees, but I am aware of Sandy Valley.
Okay, is the claim for the $27,000 at this point dismissed? Yeah, based on the motion practice.
Judge, I would argue that it is because the malpractice case is gone, and the only thing that we're left with is this emotional distress theory.
I'm reluctant to say that it's dismissed. It's still at play. Like there's been no computation of damages at this point, but obviously part of the emotional distress is going to be an argument to the jury that there's $27,000 of damages that are gone. So even if you can't find the defendants liable for malpractice, still you can assess that as part of Mr. Zitch's damages for his emotional distress.
Okay. Under NAR 3A, the district courts have held that it has to be a probable jury award, and I focused that you kept stating that they could award this for intentional infliction of emotional distress, and I think that really is, for it to be probable, it needs to be more likely than not, and in this case, at this time, and I understand things may change, but at this time, I do not believe, I don't see that the probable jury award is in excess of $50,000 based on the fact that the damages, which may or may not be dismissed, are 27, and there's only there's a potential possibly, but you even stated they could award the additional for intentional infliction of emotional distress. So at this time, I'm going to keep the case in arbitration, Certainly, if things change or there's other factors that you think I need to reconsider, you can readdress or renew the request for exemption from arbitration at that time if there's new information for me to reconsider.
Okay, and just a quick question, Your Honor, for clarification for my client. Given the significant motion practice and given the questions, like, you know, even defendants have stated these are novel questions of law, and even Judge Bayless is like, this is something we don't normally deal with. That I thought would be an even stronger argument than the $50,000. The $50,000 was kind of a secondary argument, but I do think that, you know, the Nevada Supreme Court may have one case on the continuing theory, the continuing tort theory. It's mostly in the federal district court. And so I do believe that there is going to be some significant argument back and forth in terms of the application of that theory to a Nevada state case. And I'm not sure that that is appropriate. Not that an arbitrator isn't learned enough to figure it out, but I think that that's a more compelling reason than the $50,000 threshold.
The unusual circumstances of the law, you mean? Or the
Yes, exactly. And if, again, I thought it was a pretty straightforward theory when I pled the complaint, but the fact that we've engaged in a year and a half and it's been up to the Supreme Court twice on this theory, and the Supreme Court has not stated that it doesn't apply. Judge Bayless, again, had us come in 3 times about whether it applies, and I just think that it's an unusual case and it's an unusual legal theory, especially for Nevada state courts. And I totally think the legal theory applies, but I just think that it's a little bit different and unusual how this case has unfolded to put it in arbitration now after a year and a half of motion practice.
Counsel, would you address the unusual circumstances of this case and whether that in and of itself would require make exemption necessary?
Certainly, Your Honor. I don't think that the case is unusual, and I don't necessarily think that the legal theories are novel. I think that that's kind of a polite way of saying, as a defense lawyer, that I don't get it, and this is inconsistent with how I understand the law. So to politely characterize theories as novel, that doesn't necessarily mean that damages are going to exceed $50,000. We don't have any physical injury. In essence, what we have is a claim that my client's committed malpractice. The plaintiff filed a request for discipline through the state bar. That lingered in the state bar for a while. They took no action. While that was going on, my client withdrew from the litigation, and the statute of limitations for the malpractice claim expired under NRS 11.207. Then the lawsuit was filed. We filed a motion for summary judgment based on the statute of limitations, and the Supreme Court affirmed on the legal malpractice claim, but sent it back on the intentional infliction claim, saying it wasn't briefed enough below, go back and do it again. And so that's kind of where we are. And the theory is that by my clients denying negligence or misconduct in the state bar proceedings, that somehow that created an emotional distress event, but there was no physical injury, there's no physical contact. And I think that when we look at the case as a whole, there's really no chance that if the $27,000 is out, attorney fees are not compensable under Sandy River or any other statute.
Sandy Valley.
Or any contractor court rule or statute, and costs and interests are excluded. We really have just a case that's, I don't even think, close to the $50,000 threshold. So I don't think
so it remains an intentional infliction of emotional distress case.
That's the case.
I don't see that that's such an unusual circumstance that this case couldn't go forward in arbitration under the current circumstances. Again, if something changes that you feel needs to be brought to my attention to readdress whether this case should remain in arbitration, you can renew your request at that time. But for now, I think the case should remain in arbitration.
Thank you, Your Honor. Would you like me to prepare an order?
My office will prepare a report and recommendation, and then that is something that you can then address. If either side objects to the report and recommendation, that can be addressed with the judge.
Thank you very much.
Okay, it's essentially going to be stayed, though.
Yeah.
Okay, all right, we'll talk. Thank you, Your Honor.
Thank you.